Test. Everything's good. Hopefully.
Yes, I can hear you. And the
Sweet.
video
Thank you
is
so much.
clear. Yep.
Awesome. Thank you so much for seeing us today, and we appreciate your guys' time.
Not a problem. The judge will start just at 1 p.m., so we have about 20 minutes.
Cool. Thank you so much.
Hey, Stephanie, can you hear me? I'm just testing.
Yes, it's clear on my end.
Great. Thanks.
Hey, I shut that in bed. I got a
Good afternoon, everyone. Before I officially call our hearing, I just want to check in with my court reporter to make sure she is ready to go. Harriet?
I'm ready.
All right, great. Now calling proceeding number 23A-0550CP. This is a pre-hearing conference in the matter of the application of Adrenaline Driven Adventure Company, Inc. for a certificate of public convenience and necessity to operate as a common carrier by motor vehicle for hire. This hearing was scheduled by decision number R24-0005-1. My name is Melody Mirbaba, and I am the administrative law judge who was assigned to hear this case. Just want to let everybody know that consistent with commission practice, we are live webcasting this hearing. That includes both the audio and the video feed. We are also recording this hearing, and we have a court reporter taking down everything that's being said. So to help the court reporter, I'm going to ask everybody to please speak slowly and clearly, and to keep your microphones muted until it is your turn to speak. So let's get started by getting entries of appearances. I want to start with hearing from the applicant, Adrenaline Driven Adventure Company, Inc.
Yeah, my name's John Williams, Judge. I entered my written appearance. I don't know. I think it's before the 16th. I don't remember. And appearing on behalf of Adrenaline this afternoon.
Thank you, Mr. Williams. Yes, I did see your entry of appearance. I'm going to address that in a moment. I appreciate that you did that. Thank you. It helps clarify things. Let's hear from Rapid Creek Cycles and Sports, LLC, who I will call Rapid Creek.
Hi there, this is Rondo Beechler representing Rapid Creek Cycles and Sports.
All right, thank you, Mr. Beechler. And who do we have on behalf of Pally Tours Limited, who I will refer to as Pally Tours?
My name is David Smith, owner of Pally Tours. I'm representing them.
All right, thank you, Mr. Smith. So I'd like to just go over a couple of preliminary matters before we get to the main substance of the hearing today. The first thing, I guess I'll just address the party's compliance with decision number R24-0005-1, starting with the applicant. As alluded to just a moment ago, I'll just acknowledge that applicant's counsel did enter an appearance in this proceeding by the deadline that was established by the decision that I just referenced, and therefore is in compliance with that decision. Rapid Creek is also in compliance with that decision by because it filed its letter of authority on January 9th, 2024. And I'll also note that I have reviewed Rapid Creek's letter of authority and evaluated Rapid Creek's intervention. And based on both the intervention and its letter of authority, I find that Rapid Creek has properly intervened of right and is therefore a party. Next, I'm just hoping I can get, and I will put all of this in the written decision that I'm going to issue after our hearing. So don't worry about making sure you take down everything that I just said, though I will ask that everybody make notes of the deadlines and the hearing dates that we're going to establish. I do want to see if I can get clarification on a couple of filings that were made in this case that I find a little confusing. I did highlight those in the decision that set this hearing. I'll start with applicant's filings. Applicant filed what appears to be 3 different applications, one on November 3rd and then 2 on November 8th. In decision R24-005-1, I noted what I could identify as what the differences were, which seemed to relate to legal representation. So I'd like to just ask applicant, which of these 3 applications that you filed are is the application that you intend to pursue in this case, the application that's at issue?
If you don't mind, Judge, I'd like my client to answer. I'm fairly new in the case and have one copy of one application.
It's the last copy, ma'am, and Judge.
All right, let me just.
The one saying that I'll have John represent me.
Here's the thing. You filed. Oh. Hold on a second. I just want to take a quick look because there were 2. When you say the last one, there were 2 filed on the same day. So I'm trying to figure out which last one.
Right.
One was filed as confidential and maybe.
I think the only thing I changed on it was the representation. I hope.
Well, the 2 that were filed on November 8th to me look identical. It's hard to say that with 100% certainty because I haven't, I tried to do like a line-by-line review, but I could always have missed something. So on November 8th, you filed something in an e-filings that's titled application, and that was made as for some reason, a confidential filing. I think that might have been a mistake. I'm not certain. I looked at the filing and I don't see anything in it itself indicating that it's confidential. And then the same day you filed something that's called, I guess it was described in terms of type as a supplemental filing, but when you open the document, it's the application. Again, I think the same one.
It is. I'm sorry about that, ma'am. I wasn't familiar with your system.
Okay, hold on. Let me just triple check this because if we have a confidentiality issue, I also need to get that squared away. Did you intend to file your application as confidential?
Just as in like all of my business findings and all that kind of stuff. I just didn't want those kind of things to be, all over where anybody could access them. So I did file some of them confidential, yes.
You filed like a balance sheet, profit and loss sheet, and another statement as confidential. What I'm referring is to the application itself.
I didn't intend for the application to be marked confidential, no.
Okay, all right. So,
Judge, you should also know I did not know about this filing. I really don't think that my client intended me to represent it when it was filed. I came along afterwards. I think that when the box that said, "Do you have counsel?" I've represented Driven before, and they think they said, "Yeah, I got a lawyer, and here's his name." So I appreciate that Mr. Smith, for example, served me by mail. It was 2 or 3 law offices ago, but the old law office got it to me, and so that was sort of a misunderstanding as well.
Yeah, it sort of looked that way to me that it just really wasn't very clear. whether you're going to be representing. That's why I had issued the order that required that to get cleared up. So I can understand. And on it, it doesn't surprise me based on the filings, Mr. Williams, that you weren't involved in this prior to entering your appearance. I'm not surprised at all by that. All right. So based on the clarifications that I just got, what I'm going to do is just make a note, and this will go in my decision. So everybody is on the same page. We all know what the application is. It's at issue. It's going to be the one filed on November 8th. And I'm also going to make a note. There were 2 filed. You didn't intend to file 2. And one was filed as confidential and one public, and you did not intend to file it as confidential.
Thank you.
Okay. And then I also just like to see if I can get Mr. Smith to clarify. I made some, I did sort of construed you filed 2 interventions. The second one to me appeared to be just intended to supplement basically the certificate of service for the original intervention that you filed. I'm just hoping you can confirm that or clarify that for me.
Yeah, the second one was to show that I had sent by mail that other one. That's all the second one was for.
Okay, great. Thank you. All right, now let's get to the whole point, the major point of the hearing, which is to move this case forward by getting a hearing scheduled and getting some deadlines established. So the first thing I'd like to do is hear the results of the parties' conferral. Hopefully you did confer as ordered by decision number R24-005-1.
Your Honor, let me start with this. I reread your order yesterday and read it thoroughly enough that I understood I had a duty to confer. I did talk to Mr. Smith, and I think we probably spent half an hour on the phone on various things. I tried to contact Mr. Beechler, and I was not aware of his email address, although I am today, but I phoned his business a couple of times and then went on his website. And he's one of those lucky people that closes down in the winter and takes some time off. So no one answered the phone and was not able to confer with him. Although I would also tell you, I think that my client and his business can probably resolve the intervention and the issues between them fairly easily. That would be my bet.
You know, that does happen a lot in these cases. It's always my hope that disputes can be resolved without having to go to a hearing. It's always better for everybody. So I do hope the parties are able to resolve the issues. So why don't I go ahead and go through what the issues are here today that we need to figure out and hear from everybody. The first thing I need to figure out is what everybody's position is on whether the hearing should be held fully remotely, like we're doing right now, fully in person, and if so, where? And third, whether it ought to be a combination of the two. And as I noted in my decision, if we do a combination, which would allow some people to appear in person, some people to appear remotely, it would have to be in Denver because I cannot move the equipment that we would need to set that up anywhere else. So I'll start by asking the applicant, what is your position on the manner or location in which the hearing should be held?
Our number one choice would be to do it in Mesa County and do it all live in person.
Well, like I said in my decision, I would need to hear good cause to do that, particularly, and I would say ordinarily, if we didn't have the ability to hold remote hearings, everybody being located in Grand Junction would probably be enough for good cause. But we have been holding remote hearings at the commission for almost 4 years now, and we have a very good process for that. So I'm going to need to hear more than that to establish good cause.
Well, frankly, I don't know if we have more, but all the activity is in Mesa County, all the witnesses and people that might testify and offer evidence are all in Mesa County, and it would just be a nice thing to do it here and more convenient for my client and for me, and I suspect for the other parties as well. If that rises to good cause, great. If it doesn't, you were fairly clear in your order about the good cause part.
I'll just say, you know, since the pandemic, it's just been more difficult for us to travel for hearings and to make sure we have a court reporter for hearings. And in part, that is unrelated to the pandemic, simply because the commission's our hearing schedule has just gotten to be pretty packed tight, which makes traveling several hours away. It requires overnights. It makes it just far more difficult for us to accommodate. So I will say, I don't think good cause has been established yet, but I want to hear from everybody else. I'm not going to draw a conclusion until everybody else has chimed in. So let's hear from Rapid Creek.
We would be fine with the remote hearing, Judge.
Okay.
That would-
And then what about Pally Tours?
My first preference would be, remote is fine by me. I'd rather not go to Denver. If someone else was going to Denver and it was a hybrid, then that would work for me. But my order would be remote, you know, then, or a hybrid, and then in Grand Junction would be my third choice.
Okay. All right. Based on what I've heard from everybody, I think I don't think good cause has been established to come in person to Grand Junction. So we're going to do this fully remotely. And Mr. Williams, I don't know if you've ever done our hearings. This is your first hearing with the commission, but I will tell you, if you've got some unease about it, you won't be alone. You will have help. I'll provide a lot of information. I've got legal assistants that are also very helpful, and we could even do another test session as well if necessary. But I will say we've been doing this now for several years, and we've had a lot of hearings, and we haven't had any problems. I mean, nothing that couldn't be overcome.
Is there a way to do a hybrid and my clients and I appear in Denver? The rest of it can be as remote as other people care to have it. And I'm not sure what the difference is for you if it's a hybrid session versus totally remote.
If you and your client want to appear in Denver, you absolutely can do that. But because it will be a hybrid hearing, we still have to follow the same sort of processes that we would for a remote hearing. And that's essentially ensuring that all the evidence can be presented electronically. So anybody remotely, any witnesses, any party appearing remotely will be able to access it. So procedurally speaking, it's not much of a difference, but if you want to come to Denver, you're welcome to do so. I didn't really push that option because I didn't really think you all would want to drive all the way to Denver, and I can understand why you wouldn't want to. But is that your preference, a hybrid hearing?
Well, I guess, can I make that decision as we approach the hearing date? No?
Well, I'll put it to you this way. We can set it for a hybrid hearing today, and I can set a deadline for you, and you can let me know by that deadline. If you have decided that you're not going to appear in person, then I'll just convert it to a remote hearing. What I can't do is let us decide if it's going to be fully in person in Grand Junction today. That has to be decided today. Does that make sense?
Yeah, that gives us some time to figure out how we'd like to do it, and I think that's a good offer.
That's fine. And like I said, the procedures and getting all your documents ready, it's going to be the same, whether it's hybrid or it's remote. So it's not going to change anything in terms of anybody's preparation. I'll typically set a deadline about a week in advance before the hearing for you to just make a filing and let us know whether you're going to appear in person or not. Because if you're not, then I'll need to set it for a fully remote hearing. Everything that we do at the commission has to be put in writing and in order. So I don't have the ability just to tell you all this and we walk away. Written decisions will have to go out. So I have to make sure I've got enough time to get one out for the hearing date. Okay, so with that, as of right now, what we'll do is we'll plan on it being a hybrid hearing. And for anybody that does want to appear in person, it'll be in downtown Denver at the commission's office. I'll have the address and all the information in the order that's going to go out. Now let's look at hearing dates. And looking at the statutory deadline for a final commission decision and the commission's hearing schedule, I've calculated that we need to have the hearing by the week of April 15th. And the only way we can push that out is if applicant wants to waive the statutory deadline. And I am not pressuring applicant either way. If you don't want to waive it, then we just need to look at dates in that time frame.
So I would like to have it later than December 15th, but April 15th, but my client would like to get this done as quickly as possible. I've got conflicts first 10 days of April. So
If we could push it a little bit, it'd be
I don't know if there's a way to push it anywhere beyond the 15th of April without running into statutory problems and waiver of the 210-day limit.
I think, I could certainly hold it as late as April. I could hold it on April 19th. Do you have a conflict that day?
No, I don't.
Okay.
It's the first 10 days of December of April that I have a problem. So I wanted to have enough time to prepare and be on top of my game.
I think I could even give you until April. I could even push it to April 22nd. That's one extra week later. Hearing that you've got conflicts that first week of April, typically deadlines are backed out from the hearing date. So you might end up having deadlines that fall in that time period where you're going to be, I don't know if you're out of town or what's going on, but how does April 22nd look? That gives you a little bit more time, and it gives you the weekend in case you do want to travel to Denver.
That's fine.
Okay. What about Rapid Creek? Does April 22nd work for you?
Yes, it does, Judge. Thank you.
Thank you. And then Pally Tours?
Yes, April 22nd is fine. Thank you.
Okay. Now, typically how I like to do things is set a deadline for everybody to file and serve exhibits, exhibit lists, and witness lists. And I set those deadlines to be simultaneous, so everybody gets to see everybody else's evidence at the same time. And then after reviewing that evidence, if you decide you want to add another witness or more exhibits, I will have a second deadline for anybody who wants to supplement your initial witness and exhibit list. That way, everybody has a full opportunity to see the evidence before the hearing. So I want to, let's see, I'm looking at the calendar with the hearing date of the 22nd. I am looking at setting the initial exhibit and witness deadline for April 1st. And then the supplemental, we're going to call it an amended exhibit and witness list for April 15th, which gives about 2 weeks between the initial exhibits and the supplemental if you decide to supplement, and a full week before the hearing. Does anybody have any issues with these deadlines?
We're good.
Okay. All right. So then those will be the deadlines: the hearing on April 22nd, initial witness and exhibit list and exhibits April 1st, any amended exhibit and witness lists on April 15th. That'll also be the same date that you file and serve. Any additional exhibits. And then I just want to kind of review for everybody the process that I'm anticipating for the hearing. So the applicant carries the burden of proof, which means that the applicant will present your evidence first, and then the interveners will be able to present evidence after that. And then after the interveners have completed presenting their evidence, applicant will be entitled to present any rebuttal evidence. So that's just evidence in rebuttal to the evidence that the interveners have presented. Everybody has to be prepared to present all of your documentary evidence electronically. We're going to use this same platform. And then in terms of how exhibits are going to be brought into evidence during the hearing, we're going to use a platform called box.com. And what that allows us to do is each party will have their own designated folder that they'll upload their exhibits into. Only the individual, no other party will have access to yourbox.com folder, so you don't have to worry about them seeing evidence you're not sure you're going to use during the hearing. The commission staff will have access, but that's necessary for staff to be able to move documents into evidence during the course of the hearing. There's going to be more information that will come out after I issue my decision and before the hearing. And I've got two great legal assistants that I'm sure will provide any additional guidance that parties may need. This process has worked really well and has been pretty easy thus far. What is really important for everybody to keep in mind, if you're not coming in person, that you need to make sure you've got an operational microphone and camera and really good internet, and you're able to download and view documents during the course of the hearing. Are there any questions about our hearing process or anything that we've done here today, or any other issues that anybody thinks we ought to address before we recess?
No, ma'am. Rapid Creek has no other questions.
Thank you.
Contact information for your assistants would be helpful for me, just so I've got a real comfort level about how this all operates before the hearing.
Absolutely, and that will go in the it's either going to be in the decision or in the attachment to the decision. There's typically going to be, I think there'll be two attachments to the decision. The attachments are very important. The attachments give you a lot of these procedural details, and we'll have contact information for our legal assistants. And we have done test sessions before for people that are uncomfortable, and we can certainly set that up for you. Here, we've got this one going today. You didn't seem to have a problem, but if you want to do a test session, we can do that. We can accommodate that. We just have to be able to get it scheduled in advance.
Do you anticipate 1 day is sufficient?
Well, that I was assuming that 1 day is sufficient, but I really need to hear from the parties on that. We only have 3 parties. I mean, I've had cases with way more parties than this, and we've managed to do it in a day, but I really don't know what the evidence might be that will be presented, how many witnesses applicant may wish to call, or the other parties.
I guess I'm thinking we'll fill a day, and a day may be very sufficient. I don't know if it'll lap over or not.
Well, if we think there's a chance we're going to need more than 1 day, we need to set it now, because the hearing schedule at the commission has been pretty crazy. I won't be able to, I might have a problem getting another day if I wait. So should we set it for 2 days? You're muted.
Sorry, that would be my preference.
Okay.
I don't think we'll take a full 2 days, but I worry about only one.
I'm fine with setting it for 2 days. We have the time on the calendar right now. So we'll set it for April 22nd and 23rd. And I'll just check in with Rapid Creek and Pally Tours to make sure there's no availability issues on the 23rd in case we need to use it. Mr. Beechler?
We have no problem with the 23rd also.
Okay, and Mr. Smith?
No, Your Honor, I don't have a problem with that. I don't think it's going to take more than 1 day, but no issue if it goes to 2.
Okay, great. All right, well, I don't have anything else on my list in terms of things that need to be done here today. I will give everybody one more chance. If there's anything else you think we need to address, to go ahead and unmute yourself and let me know now.
No, thank you so much for taking the time today, Judge.
Nothing here.
All right, thank you everybody for appearing, and I hope you are all able to, now that you can all see each other on the screen, maybe this will encourage you all to take some time, set some time aside to talk to each other. If you can resolve your disputes, you can make a filing, and I can typically act pretty quickly if we have an application that's uncontested.
Rondo, just for a moment, I'll send. Am I muted?
No, you're good.
I will. I'll send you an email. Maybe we can get on each other's calendar so we can talk our issues out. I don't think it'll be hard.
All right. Thank you, everyone. We will adjourn our hearing now. Thank you. Have a great day.
Thank you.
Thank you for your time.
Thank you. Thank you, Judge.
Thank you.
Yeah, that's where you had it.